Jon Velie, CEO of OnlineVisas, and I'm here with another How to Practice Law in a Hawaiian Shirt because today is Friday. Hey, great to see you guys. I am drinking a Bud Light. This episode sponsored by Bud Light. Not that they pay me anything, but if I like it, that's what I'm going to drink. Not Corona and not Dos Equis, whose new logo is We're Not Corona. Anyway, here to talk about some immigration today. We're going to do analysis of the USCIS, which is immigration's dismal H1-B approval rating and what to do about it. So look, number one, stats don't lie. The Trump administration has had it in for the H-1B visa. H-1Bs are for specialty occupations. These are for jobs that require a minimum of a university degree. They must also pay a prevailing wage. That's like a minimum wage for the county and state where the jobs will take place. Trump says that he favors merit-based immigration, but these are merit-based immigration if there is one, and the stats say that he really doesn't. So let's take a look at what has happened to the H-1B visa in the last number of years. So in 2015, there were 368,000 H-1Bs filed. Now, there's a numeric cap on H-1Bs, by the way. Now, H-1Bs, as we said, are for all jobs that require university degrees. So that's every tech job, lawyers, doctors, accountants, white-collar jobs, not orange-collar jobs like my Hawaiian shirt job. So maybe mine would be excluded, at least on Fridays, because I wear a Hawaiian shirt on Fridays. And very seldomly, although sometimes my collars are not white. But in any case, white-collar jobs, those are really our professional jobs, and they're merit-based jobs, and they've really been getting beaten up. So in 2015, 368,000 applications were filed. Now, this numeric limit is at 65,000 with an additional 20,000 for U.S. or graduates of U.S. universities in advanced degrees, masters or PhDs. All right. So with these 368,000 filings in 2015, 95.7% of those initial filings were approved. What about an initial filing is it goes in and it comes back approved. Now, if the USCIS has a question, they will issue what's called a request for evidence or an RFE. All right. So 67,000 RFEs came out, or 22% of that 368,000 received RFEs. But still, USCIS approved 83.2% of them in 2015. All right. So less than 20% were denied, 17% were denied, and, not bad. There's some that just shouldn't get it, right? I mean, not everybody has a university degree. They don't have the right university degree. The job doesn't pay the prevailing wage. There's reasons to deny it. And immigration wasn't just, rubber stamping things in 2015. I can guarantee you that. So let's go to 2016. So 398,000 are filed. So that's 30,000 more cases filed in 2016 with a 93.9% initial approvals. So down a couple of percent, 2% down from that in approvals. 78,000 RFEs. So that's up, but again, it's up by 30,000, but only 20% of them, right? So they down 2% in RFEs from 2015, and 78.9% of these visas were approved. All right. So pretty solid, almost 80% of the cases that go to approved. That's the last year of Obama. Okay. So let's bring in President Trump, 2017. All right. So in 2017, 403,000 people still file H-1B visas. This is because our economy is humming, right? We've had progressive economy since 2008, 2009, coming out of that housing debacle we had. We're really zooming. So that's 10,000 more H-1Bs filed in 2017. 92.6 of them get approved, right? Initially, that's only a drop of 1.3%. 86,000 RFEs, or 21%. So it's a jump of RFEs, but only about a 1% or 0.8% of RFEs, but a 73.6% rate of approval. So it's 5% jump in Trump's first year. So they're starting to put in the machinations of the immigration policy, right? And we've talked about that on other shows. Stephen Miller, Stephen Bannon were really the architects on what to do here. In 2017, we saw a lot of gotcha, but for the big person, we've only dropped down 5% of that. But that 5% is not, that's a lot, right? I mean, 5% of cases were denied from the previous year. Then let's get to 2018. All right, so 418,000 people apply. So that's a jump. That's 15,000 more people, building on 10,000 more from the previous year, right? That's a big jump. Economy's still humming. We need more H1Bs. We need more professionals to go into our jobs, especially STEM jobs. These are the tech jobs, the tech sector, right? But we're turning a lot away because we have this numeric cap. But still, 418,000 people go for it. 84.5% are approved initially. This is a drop of 8%, right? 8% of them that go in are just across the board. 150,000 RFEs, up from 86, right? Or 38%. That's a 17% increase in RFEs. 62.4% are approved. 62. We drop from the Obama administration at 78% down to 62%. That is a 16.5% decrease in RFEs into 2018. What happened in 2018? Well, the memo came out. A memo came out requiring itineraries and contracts. The architects of this were really the chiefs of staff, Francis Cissna and others that came over from Chuck Grassley, the senator from Iowa, members of his staff, 2 different chiefs of staff that he'd had gone over to the Trump administration and had started building in the architecture for denying these visas. And we see 2018 is a big jump. In 2019, 420,000 H1Bs are applied for. This is an additional 2%, 84.8%. So now we're down 0.3% from the year before. 184,000 RFEs. That's 34,000 more RFEs, or 40.2%. Where over 40% of the cases go in, get RFEs. That's another 2% more. And now we're at 65.4%. So a +3. So it's gone up a little bit in an improvement from 62.4% to 65% of RFEs. And in 2020, what's happening? So in 2020, we were only 6 months in. All right, it's a fiscal year. So 6 months into the fiscal year, which starts October 1st, we have 158,000 cases that are in, 85.2%. So a little bit of improvement, 0.4% approval higher than in 2019, 90,000 RFEs. So we're tracking it the same, and a 41.7% of the cases that go into RFEs. So that's even another increase of 1.5%. And we're at 67.9% of denial. So it's improved a little bit. We were at 65. So it's improving a little bit. So what were the basis of these denials, right? So there's really 4 bases of the denials under the Trump administration. One is the specialty occupation. All right, that is the title of the job. That is what the job is, right? And that has changed a lot. One of the significant things is, as immigration attorneys, we used a thing called ONET. Right? ONET was a database. You could look at what was the percentage of people with those jobs that had bachelor's degrees, what percentage had associate's degrees, what percentage had advanced degrees, right? And you could see that. And from that, you could say, okay, this job is worthy of this. And we use this for years. I've been doing this 26 years. We'd always used it. Well, they said, nope, no more ONET. There are jobs within ONET that really don't require university degrees, or not everybody has university degrees. That was a big deal. And then so they went to the OOH, the Occupational Outlook Handbook. And then in the OOH, there's a tab, how to become one, right? So you go to the how to become one and you look at the language, and it says, is it a requirement to have this job? So that's the specialty occupation. We'll get into that. And they were denying a lot of it if they think that all or practically all of the people that had this profession had degrees or didn't have degrees, then they would deny their cases. And think about this. They've limited the amount of visas available in the tech sector in particular, right? That's the big user of this. So the tech sector has to do one of 2 things: either not hire people in this country, like sending the jobs back to India, or hire people that don't have degrees and train them up, right? So here's this catch-22. They're hiring people that don't have degrees. Now they're saying, well, there's people that don't have degrees, so it's not a specialty occupation. Gotcha. So that's what was going on there. The second thing was this Itinerary Contracts Memo that came out in 2018, right? And you see the spike in denials from that. So if you didn't have an itinerary, a all the contracts. Now, a lot of the techies, there'll be a staffing company that hires somebody. Then you'll have a vendor who has an agreement with a third party. You might have two vendors. So they might have 4 different companies that are in the middle of somebody recruiting, training, hiring, and then sending them out through a couple of different vendors agreements to an end user, right? And if you didn't have all of the contracts, and the problem was not all the vendors wanted the end user to know who the staffer was for various business reasons, or they didn't have an itinerary that was signed by the right people, or you didn't have a letter from the third party, or you didn't have the actual proof of a job, which hadn't started yet, then that was a basis for denial, all right? Then there was level 1 wages. They invented this crap in 2018. That's where you just had to before get above the line. Was a university degree required? Then they said there's these 4 levels that the Department of Labor looked at when it determined whether to give you a prevailing wage, approve your labor condition application. That's called an LCA, right? So 33 pages into a memo, there was some discussion on that. And when they first threw these at us, in late 2017 and 2018, nobody knew what they were talking about. It took us a while to figure it out. A lot of cases got denied as we were doing that. So when they looked at it, we made the argument is, look, another official from another agency has approved this. What are you doing with this level 1? Well, they decided is level 1 meant it was an entry-level job, but if you weren't paying level 2 or above, and they were doing something more significant, like if it was a senior director, a leader, or they just didn't match up the language, right? There were a lot of gotcha, and well, your language doesn't seem like an entry-level job, gotcha, they would do that, right? And then the last was right to control. So right to control is if I hire somebody and I place them in another party, then I have to have the right to control them. And that is not only just hire and fire them, but I'm in charge of what their days are off, when they go to work, if they have equipment, all these, there's 22 different factors in the Supreme Court case called Darden that talk about right to control. And so they would make these determinations and deny cases based on right to control. So what's different this year? Why did we see an uptick in these approvals? Well, first of all, litigation. A bunch of attorneys, USCIS was slammed by attorneys that did it. A friend of mine, Jon Velie, worked with ITServe Alliance that I was involved in the political action committee to select John, and he nailed them in a number of cases. And they all came out in February and March. Well, the biggest one was called ITServe Alliance versus Cissna. ITServe Alliance, an incredible organization, about 1,200 tech companies around the country, almost all of them staffing, almost all of them now many of them American citizens or green card holders of Indian descent, right? A lot of these guys are from Hyderabad and in other areas of southern India. And they would they got together because immigration was slamming them starting back in 2010, and they got together, and then it became sort of a social network and how to do business, and they've done very, very well. Incredible guys, creating a lot of jobs in America, servicing America. And when we had our downturn in 2008, they're the guys that kept our country going, right? A lot of unknowns about that, but these guys kept our country going by getting tech workers that they identified, brought over here. The Indians are literally the most educated mobile workforce in the world, and they came over in droves and helped us through Y2K. They helped us through the downturn. They're going to help us through this situation. And 2010 really kind of slammed them with a thing called the Neufeld Memo. And then again, they're getting hit hard now. So ITServe, and I was part of this group, we got together, we hired Jon Velie, and he went out and he won some great cases. Well, the ITServe versus Cissna case really nailed them on a couple of things. First, all these denials for failure to demonstrate a valid employer-employee relationship. That's what they said. So the court held that it's sufficient to establish this relationship by meeting the plain language of a regulation, right? And basically, all that the employer has to do is hire, pay, fire, supervise, or otherwise control the work of the employee. Remember I was talking about this right to control? Well, they simplified that, right? You just have to do that. You don't have to have these itineraries. You don't have to have all the contracts. You don't have to show all these other things because the regulation doesn't say you have to, right? This is immigration adding extra things. This is what happened when the Grassley folks came into immigration and said you had to add all these extra criteria and were denying cases. And they said, nope. So essentially what they effectively did is throw out that memorandum of 2018. They effectively threw out the Neufeld memo of 2010. All right. And they said that when I reasoned that the additional requirement of providing these day-to-day assignments to show that the requisite control of employee was erroneous in meeting this regulation, all right? So that's the deal there. So ITServe case addressed that CIS had denied H-1B visas for failing to demonstrate the worker would be employed in a specialty occupation due to their failure to include evidence of non-speculative work assignments for the duration of visa. That's what they're saying. You have to show what your employee is going to do for 3 years specifically if you want a visa for 3 years. And if you don't, case denied, or we'll just approve it for a very, very short period of time. What was happening is that there would be the third parties would have a 1-year contract that they would evergreen, right? And so what they would do is just go to the end of that 1-year contract and give them this. We saw lots of visas where the approval would be, like 2 weeks after they gave it back, or in some cases, the approval would time has already come and gone. So the time they gave it back to the company that applied for it, it was already expired, right? So it was crazy. So a big win there by in the ITServe case. They also gave some more guidance that Congress devised a definition for occupation, not a job. Thus, a specialty occupation would likely encompass a host of jobs, right? From trainee to expert, those sorts of things. The court stated that USCIS requires proof of preponderance of corroborated evidence that the daily assignments of the H-1B visa holders will be in their specialty occupation. And then they said this begs the rationale explanation. Very few, if any, U.S. employers would be able to identify and prove daily assignments for the future 3 years for professionals in specialty occupation. What the law requires and employers can demonstrate is the nature of the specialty occupations and the individual qualifications for those foreign workers. So a real nice clarification by the courts on that. Now, what does that mean, right? So I'm a lawyer. If I was going to hire another lawyer, this person was a foreign national, then to get an H-1B, I would have to prove that I knew every case that this lawyer was going to work on, right? Or I wouldn't get the H-1B, especially if I placed that person in another location. For example, what if I had a client across the country and we were working on a number of different things? We're placing him over there. I opened an office in Tennessee. I would have to know every case that lawyer was going to work on, whether I had that client yet or not. And that's not what the law says. And that was a huge win by Jonathan Wasden and ITServe Alliance on that. There were some other cases that came in too. So TaylorMade Software versus Cuccinelli. Cuccinelli is now the director of USCIS. The first one, Cissna, he was before. And InfoLabs versus USCIS. In all these cases, the agency determined that the Department of Labor's authoritative source for information, the OOH, the Occupational Outlook Handbook, stated that most United States workers doing these jobs have a degree in the specialty occupation, and it was typical for the United States workers to have this degree when working in their field. So the Department of Labor's position was that that they were looking at normal or typical as almost always, right? They even argued in one of these cases that it meant 70%. That was in the inspection expert case versus Cuccinelli. They said that normally meant 70%. Well, what they went back and argued is under the Oxford University Press definition is that normal or usual conditions are synonyms. So it's really, they went back to a 50%, right? 51%. So normally, most typically is 51%. It's definitely not 70%. It's definitely not 100%. And that's what immigration has been doing. So these cases that came out might have something to do with the number of approvals going up a little bit. All right. So what do we do? Right? What do we do? We brief first, right? So if we represent people, we take a look at all of these situations. You wouldn't believe how many immigration attorneys will just take a table of contents, a couple of documents like the employment letter from the staffing company, a few other documents, and package it in and throw it in. We talked to a lot of companies. 100% of them get RFEs. It's like they're doing the same thing. We had a huge regulatory change in our processing, right? When our administrations changed from the Obama administration to the Trump administration. It doesn't matter what you think about these presidents, whether you like them, don't like them, hate them, that doesn't matter. The fact is they changed. And the regulations, while they haven't they're being beat up by the courts because they didn't go through the appropriate process to change, right? Regulations have to be brought through, and there's comment times, and there's stakeholders that do that. The Trump administration just changes stuff, right? They just we're not going to do it. We're going to do it this way. And that's why the courts beat them up, because they're not following proper agency law. But it still exists. And you need to respect that it exists. So what we've done in our firm is, number one, we've studied all these different denials across the board, different lawyers, different companies. Matter of fact, we did that to present that information to John Wasden when they went to litigate, right? So what we do is we write a 20 to 30 page brief up front, right? We raise the issues of the RFE so they don't have to. And in that RFE, we give our analysis, we give our strategy, and we put this case law. But it's really important in how we do this is that we don't try to beat these guys up. They are not our opposing counsel. We cannot go with them. We have no judge in filing an H1-B visa that's going to say you're right and they're wrong. They're not going to do that. The judge and the jury is the adjudicator, and they have a lot of power. So what we do is we understand that USCIS has not made a determination to remove or rescind these memos. From them, they still have the Neufeld memo. They still have the 2018 memo, and they have a checklist based on it. So if you just go, you're wrong, you're wrong, you're wrong, that ain't going to work. So what we do is we very simply list, here's how it meets your memos. Here's the itineraries. Here's these things that exist, right? But where they don't, or it doesn't go far enough, then we lay out kind of nicely, as long as you can be nice as a lawyer, right? We lay out, here's what the federal courts have interpreted these regulations to mean. Here's the regulations we're both abiding by. Here's what the federal courts say. Here's how we suggest you look at it, right? And we put it kind of at the end. We do it that way. And what does that do? Right? It reminds them, but we know what the law is, right? Here's what we think you should follow, the courts. We're not trying to talk you into it. Just look at what the judge said, the person in the black robe, right? And if not, you're lined up for litigation, right? And that's kind of where we are. So I hope those help you. This is Jon Velie. I'm drinking a beer. I just practiced law in a Hawaiian shirt. You saw me. There's proof now. I mean, if anybody asks, I'd like to go back to you. I'm going to see if you had watched. I'm going to see if there's any comments, see if you watched there. I might come back. If someone asks me, did I really practice law in a Hawaiian shirt on Friday? I'm going to need some help, baby. So I might ask you for that. I'd also like you to, if you're watching this on YouTube, to subscribe, please. Turn on your notifications if you want more information about this. If you like it, please like it and share it. We appreciate all of that. We appreciate you. Hope you're having a great Friday. Jon Velie, OnlineVisas.com. Take care.